Hello and welcome back to course on Indian polity. And today we turn on to one of the most essential themes in understanding any nation, that is the citizenship. It is contained in the part 2 of the Indian Constitution, which lays down the fundamental principles of who belonged to India at the moment of its birth in 1950. That is, what are the provisions that we are going to see in the part 2 of the Indian Constitution defines who would be the citizen of India during the commencement of the Constitution. And for the further course of action, that is, in the coming days, the Parliament was given the authority, the liberty to decide who will be the citizen of India and how one can acquire the citizenship. Why citizenship is so important? And the very first, we should ask this question because what comes next in the part third of the Indian Constitution is the fundamental right. And fundamental rights is guaranteed to citizens who are the citizens of India. So, who will be the citizen of India? What we are going to discuss in part two. Citizenship is more than just a legal status. It represents identity, belonging, right, and responsibilities. It determines who is entitled to the full protection of the Constitution and who forms the political community of the Republic. The framer of our Constitution drafted these provisions during a time that is in 1947, 48, 49, and finally completed in 50. And this period was full of chaos, partition, we have seen migration, and creation of two new nations. Part 2 reflects the challenges of that period in addressing who would be considered as the citizen of India on day one, how the people migrating from Pakistan would be treated, how special categories like person of Indian origins would be protected, and we will discuss the details and each part of the provision will be discussed. Although the Constitution gave Parliament the power to make the future citizenship laws, Part 2 remains the foundation on which all subsequent legislation, such as we will see the Citizenship Act of 1955, was built. In this lecture, we will explore these articles one by one, understanding the historical background and see how they shape the meaning of being an Indian citizen. But before that, as usual, let us recap what we have completed in the previous lecture. In the previous lecture, we have completed the part 1 of the Indian Constitution, wherein we have talked about the Union and its territory. We have discussed Article 1 to Article 4, and we have discussed the various commission that were set up to check out the feasibility of the state reorganization on the basis of the language, and then we have seen the recommendation of Fazli Ali Commission and the status of Indian states and union territory as of 1st November 1956, that is the outcome of the first state reorganization commission 1956. And we have seen the chronological order of how the different states were came into existence and the mnemonics to remember few of them. So let us now start with the part 2 of the Indian Constitution. At the very beginning, it is important to understand that in India, what we follow is called the system of single citizenship. That is, wherever in the India you go, you are identified as an Indian, irrespective of the uh, concept in the Western, that is the other federal state like USA, Switzerland, etc., where we have the double citizenship concept, where you have the citizenship of the country as well as you own the citizenship of the state. Now, in the very beginning, we have discussed that the Constitution of India is copied from the various sources, and to that criticism, Dr. B.R. Ambedkar said that yes, the Constitution is copied since the idea of Constitution is universal and it is not new. But what makes it unique is how the different points is drafted as per the requirement of the country. And you see, though the Constitution has copied various provisions from the United States of America, but it has uniquely chosen to adopt features which suits the requirement of the India. Therefore, in India, we have the single citizenship and not the dual citizenship. So, the Indian constitution is federal and envisage a dual polity, that is center and the state. It provides only for a single citizenship, that is the Indian citizenship. The citizens in India owe allegiance only to union. There is no separate state citizenship. The other federal states like USA and Switzerland, on the other hand, adopted the system of double citizenship. I hope this is clear. Now, before we proceed with the articles of the Indian Constitution, let us understand the scenario and the historical background long back in 1947 till 1950, the period during which the Constitution was drafted. So, in India, we knew that the partition was announced, and already there were a demand for partition of the country on the regional religion lines, and the demand was made, and it was a long pending demand by the Muslim League, and the position strengthened somewhere around June 1947 when the partition was announced. So the partition was announced in June 1947, but the demand was long back. And since March 1947, it was well known that the partition is coming. Okay, so partition was announced in 1947 and got completed with the independence of India in August 1947. Now, think of a scenario that when the partition is announced, the border areas, especially that of Punjab, we there would be certain regions where the Muslim would be in majority, and there would be a certain region where the Hindus will be in majority. So those area which were given to the Pakistan where Hindus were in minorities were tried to migrate to the India. And from India, those part where the Muslims were in minority tried to migrate it to Pakistan. Now this migration started on a large scale from March 1947. Why? Because communal rights started. Communal rights started. So many Indians migrated from India to Pakistan without thinking anything. They migrated to India from Pakistan. Why they migrated? To save their life, because communal rights were going on, to save their life. And this migration started on a large scale in March 1947. Though officially announced in June 1947, but since demand was long pending, so communal rights broke out all over the country, and in March 1947, huge migration started. As per the British report, this date, 1st March 1947, is marked as the beginning of forced migration. Why forced migration? Because people did not want to migrate, but in order to save their life, in order to save themselves from the communal right, they migrated. Forced migration. Okay, so this is the first migration. Number one. Remember this point. Okay. Second, let us discuss second over here. Second, what happened after the country was divided? Now, obviously, suppose it's compared to the present scenario. I am from, let's say, suppose UP, but I have set up my business in Maharashtra. Maharashtra. My hometown, my parents are in UP. I am set up in Maharashtra. I am doing my business over there. My schools, my kids are going to the school in Maharashtra, but I owe my birth in UP. My parental homes, parental property are in UP. Now, if suddenly there is a division and it say that the Maharashtra and UP will be divided, then the people in the Maharashtra may decide to migrate to UP, but they have their business, they have their other things in Maharashtra. So after division, they people may go migrate to Maharashtra for some work, do their work, and come back to UP after division. So that was the scenario between India and Pakistan. So the people oftenly used to migrate from India to Pakistan and from Pakistan to India. So India started what we call as the permit system. What we call as the permit system. Why permit system was needed? Now, since India and Pakistan is divided, if anybody wants to come to India or anybody wants to go to Pakistan, we must be uniquely identify that the people who are originally belonging to the India and who have come from Pakistan to India just for business purpose or whatever purpose, whatever reason there would be. So we need to identify that. So for that, the Indian government started the permit system. So permit system was basically started in 1948, and to be precise, the date was 19th July 1948. This date permit was system was started because it was observed that a large number of people migrated. So distinguish between the who are the actual refugee, who are the migrants across the border. So it is very important to identify that these are the people who have migrated from India to Pakistan, or these are the people who have migrated from Pakistan to India. So in order to uniquely identify, permit system was started in July 1948. So to identify the migrant, there were three types of permit which was issued by the government. The first permit is known as the permit for permanent return. Permit for permanent return. Permanent return. Who was given this permit? Permanent for permanent return. See, this permit was given to those people in Pakistan who wanted to come to India because they settled in Pakistan. But they, at that moment of during partition, their communal rights were going on, so they did not decided to come back to India. They said, let the conditions be normalized, then we will go back to India. And then they decided that they will come and they will stay in India permanently. So they are permanently returning to India, and so they were granted a permit. So this permit were basically used. This was used, or this permit was allowed to claim this permit, the holder of this permit was allowed to claim citizenship. If you have this permit of permanent return, you can claim citizenship in India. The second permit that government issues what? Permanent permit of temporary visit. Temporarily, I am in the process of shifting my business and shifting my things and all. I did not have intention to stay in India, but I want to temporarily visit India for my work, for my near and dear ones, whatever whoever is left behind, to complete some task. So, for this type of permits, no claim for citizenship could be made. Then the third type of permit, was also known as permit for resettlement. Permit for resettlement. And again, this permit, holder of this permit can also claim citizenship. So now you have understood that there were different types of people who were to be identified and who were to be given the citizenship. Number one, the people who migrated to India from Pakistan. Okay, and they were given the permit of permanent return. And since they are migrating to India from Pakistan, so in Pakistan there may be the people who belong to undivided India, or they may be the foreigner. That is, we have seen that the many settlements such as the Dutch, the French, they brought even the English settlement, they brought the bonded laborers from the South Africa and other country to work here. So the people who were left behind after independence, they may be not properly belonging to the undivided India. They may be foreigner, and now they wanted to settle to India. So the people who migrated to India from Pakistan, they may fall under this category as well. So you have to identify that the people who migrated to India from Pakistan, whether they are the original habitant of the undivided India or they are the foreigner. Number two, people who, out of fear of the communal right, migrated to Pakistan, but after the condition get normalized, they wanted to return to India permanently. Number three, these people who are from the Indian origin, but they knew that the situation in India is tense and they have moved abroad. Like we have seen that many Indian have studied in England and they were staying in England. So these are known as the people of Indian origin who are Indian, but they are not staying in India, they are staying abroad. Another category would be those who are staying in India. You have to identify them as well, those who are staying in India, basically in divided India. You have to check that also. Why? Because since communal rights were going on and the people from undivided India, say from Lahore, they came and settled in the undivided India. So, in from that point of view, you have to also check those people who are basically in divided India are Indian or they belong to the territory of the divided Pakistan. So these were the peoples who were to be identified, and precisely when we see the articles of the Indian Constitution, we will see that the article starting from article number 5 to article 6, article 7, and article 8 cater the requirement of these four categories of people. So these article number 5, 6, 7, and 8 basically what they are basically establishing the citizenship citizenship for people on the commencement of constitution. जब कॉन्स्टिट्यूशन इन्फोर्स होगा उस डेट पर कौन कौन ऐसे लोग होंगे जो इंडिया के नागरिक कहलाएंगे, और फिर उन्हीं लोगों को क्या दिया जाएगा, गारंटीड फंडामेंटल राइट्स, जो हम आगे वाले पार्ट में पढ़ेंगे. So I hope the background is clear to you. Now let us move to the articles of the Constitution and take this article one by one and start explaining them. Okay. So the first article read the citizenship at the commencement. That is, a person can become an Indian citizen on 26 January 1950 if all three conditions were satisfied. Article 5 says that there it is talking about the people who are living in India. Living in India. Okay. What it said? It said that a person who became an Indian citizen on 26 January 1950, if the date of commencement of the Constitution, if all three conditions are satisfied. Number one, you have domicile in India, that is the essential condition. You must have house in India, domicile in India, resident in India. Okay. He she must be have a permanent home in India. That is, you have bought a property and you are staying in India. If you have owned a property in India, that means the you are Indian. If you have owned a property, that means you were staying here. You had intention to stay here. Therefore you have bought the property. So the first and essential condition is that you must have domicile in India. The second, any one of the following must also be true. That is, number one, you should be born in India. You have first condition, that is the essential condition under Article 5 is you must have domicile in India. Then plus above that condition, any of the condition from part 2 must be satisfied. Born in India, that is by birth. Either your parents were born in India, that is by descent. then resided in India for at least 5 years immediate before 26 January 1950. So these three condition, any of these three condition, if you satisfy, then you are the citizen of India as on 26 January 1950. So these basis, that is the by birth and by the descent, and this is basically by registration. So if you have studied in India, like you have a domicile in India, but you are like neither born in India, you neither of your parents were born in India, nor you have stayed in India like for 5 years, so you cannot be a citizen of India. Although you have bought, for example, many of the Indians have bought property in USA or in say England. So are they becoming the citizen of in the England? No, because yes, they have the intention to stay in England, but they are not intention, and they have no intention in staying permanently in England. So same case in India also, you should have a domicile in India plus any of the three condition must be satisfied. So now these three condition has also become the base for the legislation, base for legislation by parliament. Now when parliament will make law, so this article 5, 6, 7, 8, this regulate the citizenship on the date of commencement of the constitution. So to regulate the citizenship after that, after beyond 1950, parliament will make law, and parliament will make law on the basis of and the very basic or the foundation is the article 5 part 2. So I hope this is clear. Then Article 6 talks about the people who migrated from Pakistan to India. They said that okay, the migrants who came before July 1948, that is before there were no permit system, and if they came before that date, they will automatically become um, uh, uh, the residents in India, resided in India since migration, then they become immediate citizenship. So if you came before the permit system was started and you stayed in India, you become the citizen of India. But after the permit system was started, that is 19 July 1948, and you came after that, then you need registration by the government officer, and you have to stay 6 months before registration. So you have to stay the 6 month in India, and then you go to the government officer and you register yourself as a citizen of India. But since you are coming after July 1948, so you must have the permanent permit. You show that permit, you register yourself as the citizen of India after staying 6 months before registration. Article 7 talks about the other category who migrated due to fear, due to communal rights, in hurry, without proper thinking. They did not want to migrate, but were forced to migrate to save their life. But later, after the situation is normalized, they wanted to come back. That is the citizen who migrated to Pakistan, but later they wanted to come back to India. So for those who migrated to Pakistan from India after March 1, 1947 is taken as the deadline, but later returned to India for resettlement could become an Indian citizen. For this, again, he had to be resident in India for 6 months preceding the date of his application for registration. You have the permanent settlement permit with you. You stay in India for 6 months and go to the registering office, show that permit, that I have permit for the permanent settlement over here, because I had my settlement over here, but I went for this and this reason, so I want the citizenship. After 6 months of stay, remember the date is the year, the time period for stay is 6 months. You can register yourself as the citizenship. Okay. Article 8 says the citizenship of those people who are of Indian origin but are living outside India. It says that a person residing outside India could register as an Indian citizen if either your parent or grandparent was born in India and he was registered as the Indian diplomatic or consular office. That means I am staying in England and I will be called as my origin is based in India if either my parents or my grandparents were Indians. So if my grandparents or parents were born in India and I am registered at the Indian Diplomatic Consular Office, I will be called as the uh, person of the Indian origin and I can get the citizenship of India. So Article 5, 6, 7 and 8 regulates the citizenship till the commencement of the Constitution, that is 26 January 1950. Now let us talk about the generalized article, which is still valid even after the enforcement of the Constitution. That is Article 9, which talks about a person voluntarily acquiring the foreign citizenship. Now, if you are acquiring the foreign citizenship, that means you are holding dual citizenship. But Indian Constitution does not allow the dual citizenship, so automatically the citizenship of India will get cancelled. So Article 9 says that if Indian citizen voluntarily acquires the foreign citizenship, he loses the citizenship of India, since India does not allow dual citizenship. What does India allow is overseas citizen of India, and that we will see. A overseas citizen of India is nothing to do with the citizenship. Like it is not the offering dual citizenship, that you are Indian as well and you are also holding the overseas citizen of India card. That is a different thing that we will see in the just in 10 to 20 minutes of this video. Then Article 10 is continuance of the citizenship. That means that it is not nothing like a license or a passport that you have to renew. Once you are the citizen of India, you continue to be the citizen of India unless you lose your citizenship. And how do you lose your citizenship? If you acquire the citizenship of any other country, you lose your citizenship. And the other manner in which you can lose your citizenship will be decided by the parliament. So the parliament in Article 11 has the authority to regulate the citizenship. So the parliament shall have the power to make any provision with respect to the acquisition and termination of citizenship and or all matter relating to citizenship. So the parliament will basically regulate the citizenship, the matter of citizenship, post regulate citizenship post which date? Post 26th January 1950. After that, if anybody want to be a citizen of India, then the parliament will regulate that how he would be the citizen of India. And for that, the parliament has uh, enacted a law which is known as the Citizenship Act of 1955. This act has been amended multiple number of times from time to time, and the latest amendment which was like the most discussed topic, that is the Constitutional Amendment Act in NRCCAA, that basically promised to give the citizenship on the basis of the religion, that is the minorities, Hindu minorities living in the countries of Pakistan, Bangladesh, Afghanistan, and etc. That was the recent amendment of the Citizenship Act of 1955. So the Citizenship Act of 1955 was made by the Parliament under Article 11, because under Article 11 we have seen that the Parliament has authority to regulate the citizenship, and this act basically regulate the acquisition of the citizenship, how you can get the citizenship, termination of your citizenship, how your citizenship can be terminated, how you could be deprived of the citizenship, and the registration procedure and the naturalization process through which one can become the citizen of India. Now, now, remember when we discussed the article number 6, we said that, sorry, article number 5, we said that the the people of India who have their residence in India can become the citizenship if the following of the three conditions or any one of the three conditions is satisfied. And those three conditions were by birth, by descent, and by registration. So these were also the basis of the Citizenship Act of 1955. And this act provides that post 1950 citizenship rule. This act is basically regulating the citizenship post 1950, unlike Part 2 of the Constitution from Article 5 to 11, which only dealt with the citizenship at the commencement of the Constitution. After that, these articles are no longer applicable for the citizenship post 1950. Only when the Constitution is enforced on that date, who will be the citizen of India, that deals the Article 5 to Article 7, 8. No, the Citizenship Act provides the how you could become the citizen of India, and there are the different process. The first one is called the citizenship by birth. If you are born in India, you are by birth the citizen of India. Now, there as from time to time there were different amendment which were brought into the Citizenship Act, and these amendment has brought in the different date. So according to the amendment, if you are born between 26 January 1950 to July 1987, then you are citizen by birth irrespective of the parent citizenship. If the parent are your mother and father belong to America, they came to visit India on a tour, and you were born in India, so you are the Indian citizen by birth, provided you were born between this date. Then the Second Amendment brought and said that if you are born between July 1987 to 3 December 2004, then you will be citizen only if either of your parent is an Indian citizen. Then another amendment was brought. He said that if you are born after 3 December 2004, then citizen only if at least one parent is an Indian citizen and another is not an illegal immigrant. So they try to put little restrictions. At the very first beginning, they said that if you are born before 1987, automatically you are Indian, irrespective your mother or father is a criminal, they fled from their country and they are illegal immigrant. But if they have a son in India, he will be given the citizenship and he will enjoy all the right. Then they bring on the modification that no, if you are born in India, then either of your parent, either your mother or your father, should be Indian citizen. Then only you will be the citizen of India. And then the latest amendment said that okay, either your mother or your father should be the Indian citizen, and the other parent should not be an illegal immigrant. For example, I am India. I am an Indian. I married a Bangladeshi, and she is an illegal immigrant. She came to India without any valid document, and then we married and we got a child. So my child by birth would be Indian citizen if I am able to prove that my wife is not an illegal immigrant. So this is the first process, that is citizenship by birth. Then we have the citizenship by descent. And in descent, a person born outside India becomes a citizen. If I am an Indian and my wife is an Indian and I went on tour to America and I gave a birth to a boy or a girl, then for birth before 10 December 1992, father must be an Indian citizen. For birth after 10 December 1992, either parent must be an Indian citizen, and after 3rd December 2004 must be registered at an Indian consulate within 1 year. That is, within 1 year, my birth at the foreign soil should be registered with an Indian consulate. Now, as far as this date are like uh, date are concerned, that whether I have to remember this date is not required, not mandatory. Also, from this part, the expected questions are very less, very few. Nevertheless, if you are good at mugging up, like remembering the things, you can just remember this thing to be 100% sure of not missing a single question. So, a person who enters in India without a valid passport or a visa, who is illegal immigrant. So, this is the definition of the illegal immigrant. We said that if you are born after 3rd December 2004, then you will automatically become an Indian citizen if either of your parent is Indian and the other one is not an illegal immigrant. So illegal immigrant means a person who enters India without valid passport or visa and stay beyond the permitted time is an illegal immigrant. Illegal immigrants cannot acquire citizenship through birth, registration, or naturalization unless exempted under the CAA of 2019. Citizenship Amendment Act of 2019. Okay. Now, the third process to become an Indian citizen is by registration. So, for registration, you have to stay at least 7 years continuously in India before going for registration. So, for people such as the people of Indian origin residing in India, person married to an Indian citizen, minor children of Indian citizen, and overseas person of Indian origin who want to settle in India. My wife is a foreigner. She can get the Indian citizenship after staying how many years in India? For continuous residence of 7 years. Why continuous residence? This shows an intention that you truly want to be an Indian citizen and not for getting the benefits you are trying to get the citizen of India. So this is the citizenship by registration, and we are discussing what? We are not discussing the articles. We are discussing the Citizenship Act of 1955. So we have seen that there are four processes to become the citizen of India. Number one is by birth. Number two is by descent. Number three is by registration. And number four that we are going to discuss is by naturalization. This is number four. Naturalization are given to the foreigner and those foreigners who are not illegal immigrants who have lived in India for 12 years, 11 years plus 1 year immediately preceding application. have a good characters, and know the Indian languages, any of the languages mentioned in this 8th schedule. The government may relax these 2012-year rules for the distinguished person. For example, Adnan Sami, the famous singer from the Pakistan, is given the Indian citizenship. So, if you are a distinguished scientist or you have done something very great for the country, so the government can relax the 20-year tenure for you, and you can become the citizenship or citizen of India. The last process by which you can become the citizen of India, and that is the process number 5, is by acquiring a territory, yeah, incorporation of the territory. For example, if the India acquire any territory, the people of that territory automatically becomes the Indian citizen. And we've seen the Pondicherry, Goa, Daman and Diu. The acquired territory and the people who lives in the territory becomes automatically becomes the Indian citizen. So we have seen for the citizenship, you have five different process to become the citizen of India under the Citizenship Act of 1955. And what are the mode of loss of citizenship? How you will lose your citizenship? The lose In order to lose your citizenship, there are three ways which is defined in this Citizenship Act of 1955. The one is renunciation. Renunciation means you are voluntarily giving up the Indian citizenship. Also, we have seen that the Article 9 says that if you acquire the citizenship of any other country, your citizenship will automatically be cancelled. So the renunciation is one process in which you voluntarily go and say that I do not want the citizenship of India. I'm going to become the citizenship of United States of America. That is one process. Another is termination. Termination means voluntarily acquire the citizenship of any other country. Then your citizenship is termination. This is what I was talking about for article number 9, that there is a renunciation, there is termination. Termination and renunciation is somewhat similar, but in renunciation, you voluntarily gives up. You do not want. That is due to the requirement of the dual citizenship. And termination is basically you voluntarily acquire. So you do not give up your the citizenship, but you voluntarily acquire, and you know that once I acquire the citizenship of any other country, my citizenship would be terminated. There is a slight difference in it, and that you should note. Then we have the deprivation. Deprivation means you are deprived of the citizenship. You do not want to lose your citizenship, but you have been deprived. Why? Because you have obtained it by fraud, you have presented the false document, you showed disloyalty, you have done some illegal activities or false representation, or you have lived abroad for 7+ years without registration. Only applies to naturalized or registered citizen, not by birth citizen. The condition that you have been living abroad for 7 more years without registration. If you have obtained the citizenship by naturalization or by registration, in both these cases, if you stay outside the country 7 years, more than 7 years without any registration, you will lose your citizenship. That is called as deprivation. Then in 2019, we have the latest amendment to the Citizenship Act, which is known as the Citizenship Amendment Act of 2019. And the amendment provides citizenship to the Hindus, Sikhs, Buddhists, Jain, Parsis, and Christians from Pakistan, Afghanistan, and Bangladesh who entered India before 31st December 2014. So, exempted this group from being treated as an illegal immigrant, because those who have migrated from these countries, even if they do not have the valid document, they are illegal immigrant. They will be given as the citizenship, provided they will must belong to any of the six religious community. And fast track the citizenship through naturalization. Earlier for naturalization they were 7 years, now 5 years instead of 11 years. So in naturalization we have seen that 11 years were there. So remember, for naturalization, there is basically 11 years plus 1 year immediately preceding application. And under the article for registration, you have to continuously reside for 7 years. Note the difference. For registration, how many years you have to reside? That is for 7 years. For naturalization, that is 11 years. And these 11 years have been reduced to 5 years in the latest amendment of 2019. Now, the overseas citizen of India, earlier, the Indian government used to follow the two separate scheme. One is was the oversee this person of Indian origin. Another was called the NRI. So a person of Indian origin. Another was the overseas citizen of India. Now the non-resident Indian is different from the OCI or PIO. NRI means these are Indian. They do not have to register themselves as Indian, or they are have to get the citizenship. They are Indian, but they are living abroad. Those who are working abroad, those who are studying abroad, all these are non-resident Indian. They do not reside in India because most of the time they are abroad, either for work or they stay abroad. But they are the Indians. So if they are the Indians, then they have the voting rights. They have the voting rights. These are called the non-resident Indian. Now, the two scheme that the earlier the Indian government was operating in both individually. One was the overseas citizen of India. Another is called the person of Indian origin. Person of Indian origin, and these two scheme basically merged, and then merging of these two schemes into a single scheme, which is known as the Overseas Citizen of India card holder. This is what we have as of now. Merger of these two schemes. So the government of India decided to formulate one single scheme after merging PIO and scheme OCI containing positive attitude of both. That is the person of Indian scheme and overseas citizen of India. These two schemes were merged, and then a new scheme was formulated that is called as the OCI card holder. And hence, for achieving this objective, the Citizenship Amendment Act of 2015 was enacted. So the merger was done by the Citizenship Amendment Act of 2015. And remember, for naturalization, the year has been reduced to 5 years from 11 years, and this was done by the Citizenship Amendment Act of 2019. Just remember these 2 points. 2019 and 2015 is important. Now let us discuss what do you mean by the OCI card holders. So OCI card holders are basically OCI card holders. Who are they? OCI card holders are basically those people who at one time were eligible to become the Indian citizen, but they did not registered to become the citizen of India. Now they are staying abroad, they are living abroad. But since their parents or grandparents were living, or great grandparents are living in India or were living in India, and they have their relatives in India, so they are having some sort of connection with the Indian people. So these are called the overseas citizen of India, and they are given some special privileges. For other people, for other foreigner, they may require a visa as many as time as they wish to come to India. For these people, those who are the OCI card holder. For these people, the government may relax certain norms. Maybe they may be given a lifelong visa, one visa issued, and they may visit India as many number of time as they want to visit. So let us see what is the registration process, and the registration is being done by the central government. The registration is done by the central government. So under OCI card holder, who will be given the OCI card holder? The adults above 18 years of age, the minor, and the spouse, foreigner spouse. I am Indian. I am the OCI card holder. Then my wife, obviously, I am staying in Finland. So my wife is also from Finland, but I am an OCI card holder. What would be the status of my wife? Whether she will be allowed to visit India any number of times on a single visa? That is the case. So for the adult who want to become the OCI card holder, so eligibility would be who were Indians. They were Indian at one point of time, but their termination of citizenship has been terminated, or they have renunciated their citizenship, or they were eligible to become Indian. Please write down, I'll dictate. Okay. So they were Indian, or they were eligible to become Indian when during the commencement of the constitution. So, point number one. Point number two, they belong to a territory. They basically belonged to a territory. Write down. They belonged to a territory that become the part of India after 15th August 1947. Then they can become the OCI card holder. Or they are the children, great children, great grandchildren of these people. Who's who's they are the children of these people. The first they were Indian or they were eligible to become Indian on the commencement of the constitution, or they are the children, great children or great grandchildren of such persons. Also, if they belonged to the particular territory which becomes a part of India after 15th August 1947, or the children, great children or great grandchildren of such person who belonged to a territory that becomes the part of the Indian constitution, basically part of the Indian territory after 15th August 1949, 1947, then they become the eligible for the OCI card holder and they can register. Then for minor child, basically, if your parent is an OCI kind of card holder, minor child also become the OCI card holder. For spouse means if you are a male, then your wife is your spouse. If you are a female, then your husband is your spouse. So if you are a spouse and if your husband or the partner is Indian or OCI card holder, then you can also become the OCI card holder. And the condition is that you have not married just to get the OCI card holder. And how you will prove that you are not married to just become an OCI card holder? That means at least your marriage should be 2 years old. ऐसा नहीं कि आज शादी के कल कार्ड लिया परसों तलाक हो गया, ऐसा नहीं होना चाहिए। शादी आपकी कम से कम 2 साल पुरानी होनी चाहिए, ठीक है। Also, the government of India may put certain restriction that the people belonging from these countries may not apply for the OCI card holder or may not be given the OCI card holder. Such countries include Pakistan, Bangladesh as of now, and may include some other countries as may be notified by the government of India or the parliament, whoever may notify. The registration is being done by the central government, so he may notify that the people from this country may are not eligible for the OCI card holder. So what would be the rights that they would be given? Why one should register for the OCI card holder? The rights is that they get some special privileges, which I have already discussed, that they may be given the lifelong visa, entry visa, without requirement of re-registration or re-application each time. They may give parity with the non-residential Indians, parity with them in some certain matters. ठीक है, सम सर्टेन मैटर्स में उनको एनआरआई के बराबर पैरिटी दिया जा सकता है, ठीक है। अब ये भी समझना है कि ओसीआई जो है इट इज नॉट डुअल सिटीजनशिप। ओसीआई इज नॉट डुअल सिटीजनशिप, okay। And also you do not become eligible to all the political right and all the fundamental rights. No, that is not the case. So the rights may be defined or notified by the government of India. Then how is your OCI cardholder membership got renunciated? That means this is renunciation is always voluntarily. So you may by declaration say that I do not want the OCI card holder. So your declaration is going to be registered. If it is registered, you're giving the declaration and your declaration get registered, then you ceased to be an OCI card holder. And the moment you become ineligible for OCI card holder or you cease to be an OCI card holder, your spouse as well as your minor child who were the OCI card holder just because of your status being as of the OCI card holder also loses the OCI card holdership. I hope this is clear. Okay. So renunciation is voluntarily. You go to the registration office. You register your declaration that I so and so did not want the OCI card holder, and renunciation will be done. Then there is a cancellation. Cancellation, there are various grounds for cancellation of your OCI cards. First of all is if you are basically a threat, if you possess threat to sovereignty, integrity, and unity of our country. Station option number two, and that is the option valid option. That is if you have obtained the OCI card holdership by fraud, by giving false information. Option number three, if you have shown dissatisfaction toward constitution, shown dissatisfaction towards constitution. Other point for your reason for cancellation of your OCI card holdership is you have traded or communicated with enemy. Enemy means the enemy of our country during war, and you today you have registered for the OCI card holder, and then within 5 year within 5 year of your registration you are imprisoned for 2 years. Then also your membership will be cancelled. Suppose I registered today and within 5 year I got imprisonment for 2 years in any country in which I am staying, then my OCI card holdership will be cancelled. Also, if I am a spouse and I have taken the OCI card holder on the spouse ground, I my membership would be cancelled if my marriage is dissolved. For example, I'm an Indian, so I married for example, say Russian wife, and my wife got an OCI card holder because I am an Indian. But after she got the OCI card holder and she started getting privileges in India, she dissolved the marriage. So once she dissolved the marriage, the card, her membership will also be OCI card holder status would be dissolved too. Or if I marry some other one, that is marry someone else, if I marry someone else also, then since she is no longer my wife, then her OCI card holder status will be taken away. So this is with respect to the OCI and the citizenship. I hope we have dealt in detail of the article of the citizenship, and we have also seen in depth the Citizenship Act of 1955. With respect to the different date, at least 1948 and 1st March 1947 would now be got by heart, that there should be no problem in it to remember that. As far as the Citizenship Act 1955 is concerned, and various date in that different section is mentioned, it is not required to remember that by heart. Just remember the process in which is required for the registration under the CA, Citizenship Act of 1955, and how you get a citizenship and how it is terminated. That would be like fine. And the latest status, for example, let's say suppose I see by birth. So the latest status would be I should be, if I am born in India, then at least one of my parents should be Indian and the other should not be an illegal immigrant. That is what the latest status to get Indian citizenship by birth. So if you talk about by descent, then you said say that if I have born on a foreign soil, that my birth should be registered with an Indian consulate within 1 year. So that is what is called as the latest status for the citizenship under the Citizenship Act of 1955. So thank you very much for staying with me and watching this the video for all this long duration. I understand that the videos are going a bit longer, but I cannot do anything in it because I have to explain each and everything. Because in the very beginning, I said that this video series would be catering the need of those who are the not acquainted with the Indian polity, and so I'm trying to cover the very basics and starting from very scratch, and then going and covering each and every article in detail. The notes of this would be uploaded on their website, that is the ayuconsultancy.in, as well as will be shared on the community on request basis. So thank you for being with me, and have a nice day.